Hello friends, in today's session we are going to discuss the case Swamy Atmanand versus Shri Ramakrishna Tapovanam. Let us first understand this case in brief. In this case, the first respondent Tapovanam was a registered society founded by Swami Chidbhavananda. The appellant, who was initially an ordinary member, became a monk and was engaged in various activities under Tapovanam. He later claimed ownership of the educational institutions established in Karur, which was denied by Tapovanam. The subordinate court, district court and high court all rejected the appellant's claim and recognized Tapovanam as the rightful owner of the institutions. The Supreme Court also dismissed the appeal, stating that the case falls under the principle of res judicata, which prevents the same dispute from being raised repeatedly in court. The court held that the appellant was merely an agent of Tapovanam and had no independent ownership rights over the property. Now let us study this case in detail. Answer: Swamy Atmanand Appellant versus Sri Ramakrishna Tapovanam Respondent. Reference: AIR 2005 SC 2392. Case overview. This case is based on the principle of res judicata as described in section 11 of the Code of Civil Procedure. Facts of the case: the first respondent Tapovanam is a registered society founded by Swami Chidbhavananda, actively functioning since 1942. Swami Chidbhavananda promoted the ideas of Swami Ramakrishna Paramhansa and Swami Vivekananda. The institution initially started its work in Ooty and later relocated to Thiruparaithuri. Over time, it established branches at various locations including Birudvedgam, Kutrallam, Chitrachavadi, Thirunelveli, Kodaikanal, Ramanathapuram, Rameswaram, Salem and Karur. These locations housed educational institutions, ashrams and dispensaries. Swami Chidbhavananda during his lifetime collected public donations and acquired various properties which later became the assets of the trust. The first appellant was an employee in a mill in Coimbatore. He joined Tapovanam as an ordinary member and became a monk in 1970 after taking sannyas. He was assigned work at Birudvedgam and later transferred to Karur in 1976. Tapovanam established several educational institutions in Karur with donations received from the public. In 1987, the first appellant registered a new trust named Sri Ramakrishna Ashramam Trust. He claimed that all the institutions in Karur were established with his personal funds and the money he collected individually. Subordinate court. In 1990, the appellant filed another suit in the district municipal court, Karur, which was later transferred to the subordinate judges court in Karur. The case concerned two educational institutions. Point A. Shri Vivekananda Higher Secondary School for Boys. Point B. Shri Sharda Girls Higher Secondary School located at Pashupati Palayam. In 1991, the first appellant filed a declaratory suit in the subordinate judges court Karur, claiming ownership of 6 educational institutions along with other members. This suit was later withdrawn and dismissed. The subordinate judges court Karur dismissed the suit, ruling that the first appellant was merely an agent of Tapovanam and Tapovanam was the rightful owner of the educational institution and agencies in question. District Court. An appeal was filed in the district judge courts Tiruchirappalli, which was also dismissed. High Court. A second appeal was filed in the Madras High Court, which was also dismissed. While the High Court proceedings were ongoing, Tapovanam filed a case in the subordinate judges court, Karur, which was later transferred to the district court. In their written statement, the appellants made the following arguments. Point 1. Appellants 2 and 3 were independent trusts. Point 2. Tapovanam did not provide any funds for establishing the institution. Point 3. Appellant 1 was not an agent of Tapovanam. On the other hand, Tapovanam not only denied the appellant's claims but also asserted its ownership over the disputed property. It was established that Tapovanam was the recognized educational agency for these institutions. The appellants argued that the documents in Tapovanam's name were prepared by the first appellant out of respect for its founder, Swami Chidbhavananda. However, this argument was rejected. In the second appeal, the High Court concluded that the schools in question were recognized under the name Tapovanam and all official records were registered in its name. The correspondence regarding the institution was conducted by the second appellant, who functioned as a correspondent cum secretary. The schools were built on leased land and the lease deeds were executed in Tapovanam's name. The High Court analyzed relevant provisions including section 88 of the Trust Act and clarified that if a person is interested with protecting another's interest and derives benefits from it, those benefits must be transferred to the rightful beneficiaries. Therefore, even if the second appellant claimed ownership of the property, he was merely an agent of the Tapovanam society and could not claim independent ownership. The High Court rejected the appellant's ownership claim, affirming that the lower courts had correctly concluded that the second appellant had no legal right over the institution. The court also noted that as a sannyasi, the appellant should not have made such claims. A person committed to promoting the interest of the ashram who claims to have been guided by his guru was now acting against the ashram's interests. The court observed that the second appellant had misused the trust placed in him. The High Court explicitly stated that all claims by the appellants were dismissed, affirming that Tapovanam was the rightful owner, founder, and educational legacy of all institutions in question. The first appellant was merely an agent, correspondent, and caretaker on behalf of Tapovanam and had no independent authority. The court also noted that the first appellant acted in a fiduciary capacity on behalf of Tapovanam and did not hold any personal ownership rights. Supreme Court. After the second appeal was dismissed, the appellants approached the Supreme Court. The appellants sought permission to raise an additional argument regarding the lack of jurisdiction of the civil court in their review application, which was rejected. The Supreme Court clarified that under section 11 of the Civil Procedure Code, the principle of res judicata aims to maintain the finality of judicial decision once a dispute has been conclusively decided by a competent court. Neither party can reopen the case later. This principle is incorporated into the law to prevent unnecessary litigation and avoid harassment of the opposing party. Section 11 does not create property rights but ensure that the same dispute is not repeatedly brought before the court. In other words, the purpose of res judicata is to prevent unnecessary lawsuits and provide finality to disputes that were directly and substantially in issue decided by a court and conclusively settled between the parties. This principle not only protects protects parties from repetitive litigation but also preserves valuable judicial time. Judgment. The appeal against the High Court decision was found to have no merit and was accordingly dismissed. Legal principle established. In this case, the Supreme Court established the following legal establishment. Point 1. The principle of res judicata applies to such cases, meaning the same disputes cannot be brought before the court multiple times. This prevents unnecessary litigation and ensures judicial finality. Point 2. If a person is interested with protecting another's interest and gains benefit in the process, those benefits should belong to the rightful beneficiaries. Point 3. A claimant's assertion of personal ownership can be dismissed in the absence of substantial evidence. Please watch full video, share and subscribe to the channel. Thank you.